Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Check out this fantastic view behind us, coming to you from our central Washington location here right outside of Cle Elum, Washington. Hey, the ATF is at it again. On the heels of their smashing success on their rule with firearms with attached stabilizing braces, and on the heels of their smashing success on their rules on frames and receivers, yes, they are at it again, this time trying to redefine what constitutes an FFL, what constitutes private sales, who needs to have a license. Most importantly, how are they going to shut down all the gun shows and private sales nationwide? The problem is they may actually have the statutory framework in place. So today, let's start getting you all up to speed on how the ATF wants to disarm you this time. Okay, so what we're talking about today is the publication of ATF's new rule as it relates to private sales and gun shows, or essentially how to redefine who actually is an FFL and thus must have a license. Now, this will be the first in a long series of videos. It's 108 glorious pages of new rulemaking order. We've only had a chance to skim through it a little bit, but I do want to give you guys a few highlights about what this means. Now, for my hometown crowd here in Washington State, understand that we theoretically closed the gun show loophole way back in 2009 through Initiative 594. So there really isn't anything in this federal legislation that's going to affect folks here in Washington State. For the rest of you who live in states more resembling freedom, understand that anytime the federal government is copying a plan that the state of Washington already implemented as it relates to firearms, that does not bode well for your rights. Now, one of the big concerns that we have, unlike the rule that dealt with attached stabilizing braces, unlike the rule that dealt with frames and receivers, where there actually was not a statutory framework in place. Essentially, they were defining terms that needed no further definition. In this case, as we know, for those of you who've geeked out and you watch this video or you watch this video or this video here, you will know that when we passed the Bipartisan Safer Communities Act last year, yeah, we actually provided the ATF with the statutory framework to go and do this. So what ATF now is doing is they are taking this new definition of what it means to be engaged in the business of selling firearms, a much more expansive definition, and they're going to essentially use it to shut down all private sales. They're going to use it to shut down a lot of third-party purveyor websites, and yeah, they're coming after all of your gun shows as well. So the new rule lays out a whole new series of criteria that's used to assess whether or not a person is engaged in the business of being an FFL and thus required to have a license. Now, of course, if you are engaging in FFL activity, but you do not have a federal firearms license, you will be, in fact, guilty of a felony. Now, when we take a look at the criteria, we will see that, well, just about any private sale imaginable is now going to fall under the category of this new rule. Now, of course, the current presidential administration is thrilled with this new rulemaking order, and of course, after the smashing success of their other two efforts, why wouldn't they be? According to a White House press release, the president is quoted as saying, specifically, the proposed rule, if finalized, would clarify that an individual would be presumed to be engaged in the business of dealing firearms and therefore be required to become a licensed firearms dealer and run background checks if they meet certain conditions. For example, under the proposed rule, a person would be presumed to be required to become a licensed dealer and run background checks if they meet one or more of the following criteria. So there's going to be a list of criteria here, and all you need to do is fall under any one of them, and you then, congratulations, are an FFL. The criteria include: 1. Offer for sale any number of firearms and also represents to potential buyers that they are willing and able to purchase and sell them additional firearms. 2. Repetitively offer the for sale firearms within 30 days after they were purchased. 3. Repetitively offer for sale firearms that are like new or in their original packaging. 4. Repetitively offer for sale multiple firearms of the same make and model, or as a formerly federally licensed firearms dealer, sell firearms that were in the business inventory and not transferred to a personal collection at least a year before the sale, addressing the so-called fire sale loophole. And of course, their ability to expand this definition is based on the new definition, thanks to the Bipartisan Safer Communities Act, that says that if we are doing this predominantly for profit, not engaged in our actual mainstream income, but just doing it predominantly for profit, we actually fall under the purview of this rule. Specifically, the new rule now lays out criteria that include creating a website or making business cards to advertise or market a firearms business, maintaining records to document and track profits and losses from firearm purchase or sales, or purchasing business insurance or renting spaces at gun shows. That's right, merely renting a space at a gun show will now qualify you as an FFL. And so you can see what this rule effectively does. In states where gun shows are really big attractions and a lot of people go to them, those days may be numbered. Now, the rule has been published at this point for comments. There is a 90-day comment period, which is open right now. We're going to put links down in the description box below so that you can understand how to comment. Now, I want all of you to be aware of something. Let's go back and take a look at what happened with the rule with attached stabilizing braces, because there were hundreds of thousands of comments that came in. And while I get that many of you think that these are just going to fall on deaf ears, let us not forget that after that comment period, the ATF radically, and I mean completely and radically, changed the rule as it related to attached stabilizing braces. That significant change is now the subject of one of the more successful challenges ongoing to that rule. So yes, can your comments make a difference? They most certainly can, and we need everyone to be involved in this. And this is important because this is an activity that many, and I do mean many, lawful and responsible gun owners engage in. It's one of the cool things about being part of the 2A community. But if you are found in violation of the laws related to having to have a federal firearms license, you face up to 5 years in prison and $250,000 in fines. Now, for those of you who've already been through this a couple times on the frames and receiver rule and the stabilizing rule, you'll know that there will be a comment period for 90 days. The rule will then be pulled back. The ATF will make its changes, and then they will republish the rule with an effective date. The time to start mounting opposition to this is right now. Now, we know exactly how this is going to go, though. This rule will be tinkered with a little bit. It will be published, and then the lawsuits will start flying. However, and this is what concerns me, unlike the rule on frames and receivers, which required a huge leap of faith and a step outside the statutory authority of the ATF, and the same thing happened with the rule on pistol braces. You see, the statutory framework necessary to make this happen was put in place by the Bipartisan Safer Communities Act, which again goes to show that the adage is if you give them an inch, they will take a mile, is oftentimes true when we're dealing with issues related to civilian disarmament. Listen, we'll go ahead and link up the proposed rule down below, and we will put down there all the information on how you can make public comments. I encourage all of you to do so, and to do so right away. If you have any other questions about this rule or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is right down there in the description box as well. In the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. From beautiful Central Washington, thanks for watching, and stay safe.